Federal courts and judges. Task of trial and appellate court. Trial court arraigns the defendant, conducts the trial, imposes sentences, witnesses on appeals in trial court, and is considered finders of facts. Appellate courts do not hear testimony from witnesses, conducts trial or use of juries. Instead of a single court judge deciding in a trial, a group of judges make an appellate decision. The U.S. Magistrate Judge responsibilities and workload. It performs quasi-jurisdictional tasks, work with jurisdictional branches of government, authorized to perform a wide variety of duties, responsible for preliminary proceedings, including holding initial appearances, conducting preliminary hearings, appointing counsels for indigents, setting bail, and issuing search warrants. In misdemeanor and petty offense cases, the jurisdiction is more extensive. It may impose sentences, accept pleas of guilty, and preside over trials. On the civil side, they supervise discovery, review Social Security disability benefit appeals, and even conduct full civil trials with consent of litigants. The U.S. Magistrate Judge responsibilities workloads continue. Magistrate judges play an increasingly important role in helping district courts dispose of the growing caseloads. In 2005, here are some of the numbers of the caseloads. Caseload was 1.9 million matters, 350,000 felony preliminary hearings, 95,000 misdemeanor and petty offenses, 26,000 prisoner litigation cases, and 349,000 civil matters. Their district judge responsibilities and workloads. There are 94 United States district courts, of which 89 are located within the 50 states. There is also a district court in the District of Columbia and 4 territorial district courts located in Guam, Puerto Rico, the Virgin Islands, and the Northern Mariana Islands. There is at least one district court in each state. Moreover, based on the compromise that produced in the Judiciary Act of 1789, no court crosses state lines. All trial courts for all major violations of federal criminal law. Circuit judge responsibility and workloads. Normally 3-judge panel. They have jurisdiction over a wide variety of matters. Judges normally hear cases involving more serious criminal and civil offenses. Typically, circuit court judges must practice law for a prescribed period of time before they can seek a seat on the bench. Circuit court judges preside over all aspects of felony trials, from pre-trial hearing to hearing of sentencing. Oversee the judge selection process for grand juries, regular juries, decide admissibility of evidence, consider whether attorney objections should be sustained or overruled, and instruct jurors concerning applicable law to consider during deliberation. Circuit judge responsibilities and workloads continue. A decision from the U.S. Court of Appeals exhausts the litigants. The losing party may request the U.S. Supreme Court hear the case, but such petitions are rarely granted. As a result, the Court of Appeals are the courts of last resort for virtually all federal litigation. Their decisions end the case. Only a tiny percent will be heard at the nation's highest courts. The responsibility of the Supreme Court and the workload. The Supreme Court has a special role and plays in the United States government. The Constitution gives the powers to check, if necessary, the actions of the President and the Congress. It can tell the President that his actions are not allowed by Constitution. It can tell Congress that a law is passed violates the U.S. Constitution and is, therefore, no longer a law. It can also tell the government of a state that one of its laws breaks the rule in the Constitution. The Supreme Court is the final judge in all cases involving law of Congress, the highest law of all, the Constitution. The Supreme Court, however, is far from all-powerful. Its power is limited by the other two branches of government. The President nominates judges or justices to the court. The Senate must vote its approval of the nomination. The whole Congress also has great power over the lower courts in the federal system. District and appeal courts are created by the act of Congress. These courts may be abolished if Congress wishes it. The Supreme Court is like a referee on a football field. The Congress, the President, and the state police and other government officials are the players. Some can pass laws, others can enforce laws, but all exercise power within certain boundaries. These boundaries are set by the Constitution. As the referee in the U.S. system of the government, it is the Supreme Court's job to say when the government official steps out of bounds. Only a small percentage of the request for a writ of certiorari is granted. In particular, the legal issue must involve a substantial federal question. Each case comes before the Supreme Court justice have been certified by the rule of four, which means four justices must decide to hear a case. Normally, Supreme Court hears cases for the following reasons. A, case of national importance, example, Gore versus Bush presidential elections. B, lower courts invalidates federal law. And C, resolve split decisions in appellate courts, where one appellate court rules differently from the other appellate courts. Jurisdiction and function of Article III courts. Under Article III Constitution, the United States Supreme Court justices have lifetime tenure in their position during the time of good behavior. Lifetime tenure also is true to judges in lower constitutional courts and federal system. Article III Constitution provides a federal court that may hear controversy between civilians in different states or citizens of the United States and citizens of a foreign nation. Congress, in Title 28 of the United States Code, limits the power by requiring that the amount in controversy exceeds $75,000. The broad purpose behind diversity of jurisdiction in that a state court may show bias towards its own citizen to the detriment of a citizen from another state. Jurisdiction and function of Article I Court. The U.S. Court of Military Appeals was created by Congress in 1951. At that time, Congress also enacted the Uniform Code of Military Justice, which establishes the military judicial system. This system was designated to balance the need to maintain discipline in the armed forces and to give members of the military services who are accused of crime rights paralleling those of the accused person in the civilian community. The court's jurisdiction is worldwide, but encompasses only questions of law arising from trials by court-martial in the United States Army, Navy, Air Force, Marine Corps, and Coast Guard. In cases where a death sentence is imposed, where a case is certified for review by a judge advocate general of the accused service, or where the accused who faces severe sentence petitions and shows good cause for further review. Such cases are subject to further review by the Supreme Court of the United States. The Supreme Court may also review cases in which the court granted extraordinary relief. The Supreme Court has jurisdiction to review decisions of the military appellate courts in which the United States has taken an appeal from ruling by a military judge during trial by court-martial. In the years ending in September 30th, 1992, 1,541 cases were filed in the U.S. Court of Military Appeals and 1,380 cases were terminated. The 5 judges of the Court of Military Appeals are civilian appointed for a 15-year term by the President with the advice and consent of the Senate. The Chief Justice serves for 5 years and is succeeded by the next senior judge of a court. The court is located in Washington, D.C. And then you have the page where it comes from the book.